Good morning.
Good morning. May it please the court. My name is Matt Canigliaro. I am with Carlton Fields, and I'm here today on behalf of the appellant. If I could save about 5 minutes for rebuttal.
Let me ask this. Whether we call this asset transfer a conversion or a sale, at the end of the day, doesn't the real question boil down to what did your client get in return? What is the fair market value for whatever it is that she got in return?
That is the focus of DCF's position in this case. We've made two arguments in our briefs, one focusing on one of the DCF policies, that in essence we don't have to get to fair market value because the way that policy is laid out, the other elements aren't met. But the focus of the case certainly has been fair market value. And our position is, well, let me begin by suggesting that there really are two levels to this case. The first level is what the ALJ actually did and found. And that's the finding that the operating agreement wasn't signed. Because of that, it wasn't considered by the ALJ. And because of that, the ALJ concluded that there was a zero value for the security in this case. That was never argued by the department below. It's not defended by the Department of Appeal. And this court could, although we don't request this court could simply reverse and send it back for further proceedings and go from there. Neither side is asking for that result.
How does the operating agreement get you there, right? How does tell us about the let's assume for a minute that the operating agreement matters here.
The operating agreement makes clear that this is an investment, that the person who invested is entitled to a return, and the amount to be returned is the full amount of the investment. There's actually two types of members. This was an investor member.
It seems like that's undisputed that there would be a return if the property appreciates in value, right?
Yes, Your Honor.
But when? I think that the question is when would the return occur?
The document sets out the different circumstances. It's essentially maturity, but maturity is really defined as when the underlying property, in this case it's a mobile home park, when
it's sold.
When it's sold, yes,
right.
Your Honor.
Which, and when will it be sold?
The estimate at the outset was 5 to 7 years. And there are a couple.
That isn't legally binding. They could sell it sooner, they could sell it later.
Yes, Your Honor.
It's at the sole discretion of the members, right? Of the managers.
The managers, yes, Your Honor.
So theoretically, they could sell it 30 years from now, right?
Let's
start with an easier one.
Agree, Your Honor.
Let's start with an easier one. Let's say 7 years comes and goes. Can your clients be taken to court and forced to sell?
Not under the operating agreement, Your Honor.
Under any document?
No, Your Honor. And the department's position is not that...
At what time is the money guaranteed to be returned?
It's guaranteed to be... No.
Assuming again that...
Guarantee is the wrong word,
Assuming again that the property appreciates and there is money to return, right? So let's assume that for a minute. When is the money guaranteed to be returned?
It's to be returned if the property, or if and when the property is sold, and it's to be returned...
And when she dies?
At death. And there's also an opportunity for the managers to essentially force a return at some earlier point prior to sale in their determination that that's appropriate. There's not been an argument by DCF that anything about the length of ownership here is at issue, that that's a reason for this to be determined to be of zero value. DCF's position has been, and it's essentially their tipsy coachman or right for any reason argument to defend the order in this case, is that because it was illiquid at the start, that makes this something worth nothing. That's DCF's position. That ultimately is the issue to be decided. And I believe it's the reason why both sides are not asking for this to go back before the ALJ and for further proceedings.
She can't transfer or assign her contract rights. And so
not unilaterally, although the operating agreement actually does allow it to be done authorization by management.
We have to ask for it.
I mean, anything can be done, right, essentially, if everybody agrees.
Yes, Your Honor.
Right. But on the face of it, she can't just, there's no secondary market. The documents are clear. There's no
Your Honor.
secondary market. They don't have to give their approval for a sale or a transfer. So if she came to you, assuming that the managers were in agreement and wanted to sell it to you, what are you buying?
You're buying a security.
What would it be worth? I mean, if I buy a 30-year bond, I can easily calculate the value. There's a formula for calculating the value, and then there's some magic that goes into it depending on the credit worthiness of the borrower. But how do we calculate? You're buying an income stream. She bought an income stream of $333 a month for some unspecified period of time. That could be tomorrow, could be 30 years, could be 5 years, we don't know. How do we determine the fair market value of that asset?
It's really a matter of simple accounting. And the moment that matters is when the investment is made. Here it was a $100,000 investment. What was the value of that $100,000 investment? The evidence in this case, at the evidentiary hearing that was held, was that the value was $100,000. The department didn't even try to put on any contrary evidence. And really, it shouldn't be surprising.
Your client said it was $100,000, but isn't fair market value what a willing buyer would pay a willing seller?
In this case, frankly, that's exactly what happened. This was an arm's length transaction.
Well, but it isn't what your client, she's not the mythical, reasonable person. The question is, if I want to turn around and buy that, because I am the mythical, reasonable person, if I want to turn around and buy that asset from JN, what do you think I or someone like me would pay for it, assuming that we could buy it at all?
If we're speaking mythically in today's market with a 4% annual return, at least $100,000.
Well, doesn't that depend in large part on when am I going to get my $100K back? How creditworthy is the borrower? I mean, that creditworthiness is a big factor. We don't know how creditworthy they are, how leveraged they are in the deal. I mean, all of those factors go into determining the value of the asset, don't they?
Yes, Your Honor. And we, at the evidentiary hearing, we were the only side to come forward with accounting information about the value of this property. And the department didn't even try. Their only position in this case is that because it's not liquid at the outset, that the value is zero.
Well, it's never liquid for her.
There will come a time when it matures. There are investors in this
It's an
security.
indefinite time, though.
It's an uncertain time, I think I would agree. But to go back to Your Honor's suggestion about it being decades or so, it's just so unrealistic, it's not possible. That there are investors here who have invested money. When the property reaches a certain level that folks will be well compensated for their investment, that's when the sale will happen. And the estimated time, good faith estimate, there's been no challenge to that, was 5 to 7 years.
Because real estate always goes up in value?
Well, Your Honor, I won't agree with that, but if Your Honor were to read the materials that are in the record about this particular investment, they explain why, in the case of a mobile home park like this, it is far different than most investments. For circumstances and facts that are described there, it is a very, very sound investment, and they have not challenged that.
But, I mean, I think that's what we're struggling with, right? I mean, she gets her money back if the managers decide to give it back. Otherwise, she never sees it again.
What she gets is a rate of return
Right.
that is fantastic, 4%. In today's market, that's
Her life expectancy was what? 5 point
something years. Yes, Your Honor.
5.8, I think, something. She gave $100,000, which she has no right to ever get back during her lifetime. No right. Maybe she will get it back, right? But she has no right to ever get it back. $100,000, and her return is $333 a month. Is that a fair and accurate statement of what we're looking at?
I wouldn't agree she has no right. She has a right. She owns this investment. It is hers.
Oh, she can take your client to court and get the money?
Well,
I mean, I think
there
my
may be-
challenge is that the operating agreement itself, and we can proceed from the earlier proposition that it's signed, it's enforceable, that if it wasn't considered, it should have been. All of those things I'll encompass for the sake of my question. The operating agreement specifically says it's illiquid, it's irrevocable, it's unassignable, it specifically precludes a secondary market, and you can't encumber it. So all you're getting is the 333.
Yes, Your Honor. Until something happens, such as the property is sold, or the management decides to go ahead and enforce a return, or in the event of a death.
So does that help
So-
your argument? The fact that the money would be returned upon her death?
Well, it's yet another circumstance in which this money comes back. She has a right to this money, but it is in this security. And the department's position has been, it's not that there's some issue with this length of time. The department's position has been, the value is zero simply because it's illiquid. And we have,
Bought an income stream of $333. Now, would you agree that, I don't know the creditworthiness of the mobile home park, but there's probably a difference between their creditworthiness and Prudential Insurance versus the United States government. Each of those would have different values because their credit rating is going to be different.
not necessarily, Your Honor, the record
You
here
would-
indicates only that this was a very sound investment. And again, we had an evidentiary hearing. There was absolutely no evidence that there is anything less than stellar about the quality of this investment. That's not been their
For
position.
who, counsel? For who?
For all of the investors.
She will likely never get it back, and she certainly has no right to get the money back during her lifetime. We've agreed to that, correct?
Well,
So how is it, help us understand how it's a reasonable investment for her.
it's an extremely reasonable investment.
Well, that's
She's going to get a 4% return, which is, in today's market, frankly, extraordinary. All right? She has her investment entitles her to, that part of
$333 a month.
well, that's the income stream from the return.
Right.
But she's also entitled to get back what she invested. And
But she's not. You keep saying that, counsel, but she's not, right? You've said,
she is under certain circumstances.
no, she's only when your client decides to give her money back.
Not my client, Your Honor. I'm here on behalf of the applicant.
Fair enough. Only when the managers decide to give her money back.
When the time is right to sell, that's when the sale happens.
When the managers decide
That
it's time to
that
give her
all
money
of the
back, right?
investors will be well compensated. The incentives are built into this system for the sale to happen when the time is right. And there's only one case two cases that the department relies on here. One is the Thompson case from this court, where there was a life estate that someone wanted to do Medicaid planning and essentially purchased a life estate in her sister's place. And the court said that, and argued in that case that it was not done actually with the intent to qualify for Medicaid. And the court said that there was no fair market value shown. That's not this case. Here, the only side to attempt to show fair market value was us. The evidence, and that's why we're not asking in the first place to go back for further proceedings. We could bring in an army of accountants who would meet every standard the court could request in terms of the value of this investment, how actuarially sound it is, how every concern that could possibly raised could be met on return to the ALJ. But we're not asking for that because that's not their position. Their position is the mere fact it's illiquid is the reason its value is zero. That's their argument. The law is clear. If we got fair market value, or if we intended to get fair market value, then there's no transfer penalty. And that's where we are. They cite the Mackey case out of Michigan. But the Mackey case, they cite it because it involved a situation where someone made an investment into an LLC created by the family. It was run by I believe the daughter, and it involved a period of illiquidity. 2 years. And the ALJ in Michigan said that makes it worth zero. Case worked its way up the appellate chain. When it got to the Michigan Court of Appeals, they decided that the value was zero, but they specifically rejected the exact argument the department is making here and that Michigan made there, which was that illiquidity made it worth zero.
There's a suggestion, and I can't remember if it's in the briefs or if it's in the record below, and maybe you can help me with this, that, and everybody's been admirably transparent about why this transaction was entered into. There's a suggestion somewhere, and again, I'm blanking on where it comes from, that if this didn't work for JN, that the investors would give her the $100,000 back. I didn't find that in the operating agreement, but maybe I missed it. Is that anywhere, is that guarantee written anywhere in the record?
I am unaware of that being in the operating agreement. I am
I
aware
don't think
that
it's in the operating agreement, because I looked at it a couple of times. I did want to make sure I wasn't missing it, but does it appear, does that written guarantee or does that oral guarantee appear anywhere else in the record?
it is referenced in what were some sort of attorney-focused marketing materials, but to my knowledge, it's not in the operating agreement. And if I can save the balance of my time for rebuttal.
Yes, sir.
May it please the court. My name is Shane DeBoard, and I'm representing the Department of Children and Families today.
Counsel, to the extent that you can you answer that last question that I asked? opposing
Absolutely.
counsel?
That is located in the record in the page 111, frequently asked questions, states the money will be returned to the applicant if there's a loss at a fair hearing with DCF. That is in materials that is, if you read the record or the transcript portion of the record, the department obtained that information from an attorney who was a member of AFELA, the same organization that Ms. Wakeman is a member of. And they were concerned about the information they were receiving based upon the type of, they were advertising it as income-producing property. You know, it's, like he said, you know, they say it's a great investment. My response to is it's not. The operating agreement clearly says, and I'll point to that page as well, page 317 and 318 of the record, sale of additional member interest. So there's two members that really control this from what I could tell from reading the operating agreement, but it says the managers at their sole discretion can dilute it. The original offering was $4.1 million to purchase the park, manage it, so on and so forth, right? However, they're free to sell all the more membership interest they want. They could sell $20 million in it and then sell it for $5 million later, and everybody takes a loss. But so, you know, it's not some great actuarial type thing that he's representing. That's not what it is. It's something they can dilute at will and at their own pleasure, and none of the people who put in the original $4.1 million can do a thing about it. But getting back to the actual aspect of the law that's important, all the department's policies, the administrative code, this court's ruling, and I believe the ruling in Thomas in the 4th DCA really supports this fact. Their issue is, hey, we intended to get fair market value at the time we made the purchase. However, under the law, that's not when you determine fair market value. You determine fair market value based upon what can you get for the newly acquired asset. However, let's look at the intent when they made the purchase. Here's what they did. They entered into an agreement that was clearly designed to run afoul of settled law as far as the department's policy, administrative rule, and this court's ruling in Thompson. We're going to create something that's illiquid and can't be sold, and there's no open market for it. However, all of the policy, the law, and the policy rule and the law says, what can you get for the newly acquired asset? Not what you thought you were going to get here. What you intended was to create something that ran afoul of the law, and that's what they did. And that's okay if you want to do it. You just can't do it for the purposes of applying for Medicaid, because there's certain rules that go through. You have to be able to show what you can get in fair market value for it. So their intent, maybe that's what they sold or were trying to sell, but that's not what they sold. You have to look at what they did at the time they made the agreement. Their intent was to run afoul of the law. And here's why they tried to do that. He didn't talk about it, but I'm going to talk about it. They presented a fabricated transfer penalty determination process. to the department. They have a fake Step 22 and a fake Step 23. So they want to say, okay, we took this $100,000 and we converted it to this piece of paper that says, I have 10,000 units in coastal income properties. Whatever that is, I don't really know, other than an income stream. So that's what they did. But their Step 2 says, if there's a conversion of assets, don't pursue transfer of penalty further, or review further. Go straight to Step 23, make them eligible and recorded in the system. So it's kind of the same argument. I mean, that's the way they were trying to sell it to our lawyer. The evidence is there in the record, through their emails, through Aaron Ray. He's the representative for coastal income properties. But that's the way they're trying to argue it. But if you look at page 129 through 132, there's two policies there very, very, very quickly. 1640.0407 and 1640.0408 show you, basically say, you have to determine value of what you can get for the newly acquired asset. What can you get on the open market with this? In this case, it's zero. You can't get anything for that piece of paper.
Well,
No
we've
matter
kind of
what-
danced. We've kind of danced around it up to this point, but I'd like for somebody to address it head on. I mean, there is value, right? When she dies, I think there's an 8% penalty, but at that point, her heirs can demand a return of the money for whatever the penalty. I think it was 8%, but maybe it was 4. I can't recall. So there's value to her heirs, at least, correct?
Assuming there's any money in the bank account, I don't know.
No, right. Let's assume for a minute that this is a great investment. For purposes of argument, this is a great investment. Let's assume it. And she puts this money out of her own reach so she can become eligible. And at the same time, accomplishes the task that she probably wants to accomplish of, I'm going to give this money to my son or my daughter or whatever. Doesn't this security, if you will, doesn't this do that?
No, sir. In
Doesn't?
Thompson v. Department of Children and Families, this court has already decided you determine fair market value of what the newly acquired asset can be sold on the open market. This is the same concept in Thomas. The appellant argued that this
What
case
if it simply said you can't sell it or transfer it for 60 days? Is that a
doesn't.
problem? I mean, you can't sell it for 60 days.
that's not what the agreement says.
Well, no. If it did,
I don't have an answer for that question.
so your position is that she can't purchase anything that is illiquid for a day.
I'm not saying that. I'm saying what she has to do is there has to be an open market for what she gets. The newly acquired asset, you can't take $100,000 and reduce its value down to nothing and create a situation where there's no open market.
Well, in my hypothetical, there's no market for a day because the contract says you can't transfer it for a day.
Well, I'm
She's
guessing,
ineligible now?
I'm guessing in that case, the application would have came in after that day after she purchased it, so the day would have already expired.
You're fighting my hypothetical.
But you're talking, that's the reality.
Okay, how about a year? You can't sell it for a year.
Say
But
it's one of those situations where I sell part of my company, and in agreeing to sell it, I agree that I can't move the shares for 3 years.
But life expectancy is 5.8.
Correct.
Well,
In this case.
is that okay?
I don't think so, because I think the law, the administrative code, the policies, and the law is pretty clear. This is very similar to what happened in the Thompson case. There was a life estate, a daughter granted her mom a life estate in her condominium, I believe it was. She gave her $18,000. So, but there's no open market for that life estate in her daughter's condo. It's just not something that somebody can go out and buy. That's what the law requires. You have to be able to say, okay, if you're going to get income-producing
Yeah,
property,
but in that case,
go
there's value-
purchase it. Go purchase a house.
There's value to the heir, right?
It's not about value to the heir. That is
Well,
not.
that's what I'm asking you. That was my question.
A value to the heir is meaningless.
But you didn't answer my question. I was
Okay,
asking you that
I
question.
misunderstood your question, and I apologize. However, the value to the heir is meaningless. It's the value to the applicant. Their argument is, you judge it at the time of purchase. However, the law is very clear. You judge it at the time of when the applicant makes the application. What did they do with that $100,000? Did they reduce the value in it? Can they get anything for it? Is there an open market? In this case, the answer is clearly no. That's the simple and the beautiful thing about the facts of this case. It's not a dispute. Hey, we did it, but it's okay. because our intent was this. No, their intent, based
Well-
upon the agreement, was to,
Now that we have an answer to that question, I am curious. Let's say the life expectancy is 5.8 years, and we'll go to Judge Traver's hypothetical, the selling of the business. You can't sell the shares for 3 years, but the life expectancy is 5.8. Ineligible?
I would say yes. It's consistent with the law.
So in your view, the life expectancy here doesn't matter. If they had said, if the operating agreement had said, we must sell this in 5 years,
It doesn't matter.
and her life expectancy is 20,
Correct.
you would say you're ineligible for Medicaid
Correct.
at that point.
Because the holding in Thompson from this court basically holds exactly that. It's what can you get for it on the open market? In this case, they reduced the value of the $100,000 to nothing. If whatever the heir gets is great, that's fine. But if you want, I can go through, the transfer determination, the actual transfer determination penalty process in this case. I've written it out, but it just, they want you to ignore all that. Ignore what's behind the curtain. We're going to call this conversion. Look at our fabricated steps that we've created here, 2 and 23, make it eligible and go forward. Don't worry about anything else. That's really what they were asking the department to do in this case. But that's not what's required under the law. You have to take a look at whatever you've done with your money and what have you turned it into and what can you get for it now. Now, if she would have taken that $100,000 and she would have purchased, say, a house, so to speak, right? I bought a house for, clean and clear with $100,000. It's got a 5-year rental in it. I'm getting $1,500 a month in this area of town for rent. So she would have created an income stream of $1,500 a month for herself by purchasing that house hypothetically. Well, that house is something that can be sold on the open market.
What if the lease said we agree not to sell the house for a year because you've leased it for a year?
You still have something that there is an open market for.
No, you don't, because the lease agreement said you can't sell it.
Well,
Just like the operating agreement said you can't sell
Wouldn't
it.
that affect the value? It wouldn't perhaps reduce it to zero, but the lack of marketability might reduce it somewhat because you couldn't sell it for a year.
perhaps.
Well, your argument is you have to be able to sell it on the open market day
There
one.
has to be an open market for it. It doesn't mean you have to sell it as the applicant.
So it'd be okay if the lease said you can't sell it because, well, it's a piece of property and there is an open market for property, even though the agreement says you can't sell it.
Investment property like a house is something that is a tried and true way to take your money and put it into that and create an income stream for yourself. And that house is excluded from your eligibility determination for Medicaid. Now, the income from it may not be. However, you can put that into a qualified income trust.
Are you suggesting that if the operating agreement did not say that it did not forbid transfer of the units here, right?
It did not?
Let's say it doesn't. Let's say it doesn't, hypothetically speaking. Are you suggesting that the units could not be sold? They could not find a buyer for them?
I don't know. I mean, I understand the hypothetical. I guess if there was an open market for this transaction, maybe the department's position would be different, but that's not the case here. It's clearly contractually, you can't sell it.
But you just said the property, even if it was contractually, even if by contract you couldn't sell the property, that it would still be okay because there's a market for property. That's what you just said.
For a house, correct.
So in this case, are you suggesting that there is absolutely no market for units like this, that they couldn't be sold
I'm not saying
if
that-
the operating agreement allowed it?
I'm not saying there may not be. I'm not a person who understands investments by any means. But under the law, the way they've structured their transaction, their intent was to create a market a liquid investment where there is no market. It cannot be. It can't be purchased. I mean, those are the facts. Nobody
Just
else.
ask the question maybe in a different way. Is it
Okay.
the department's position that in order to have fair market value, that an asset must always be liquid at all times?
If you have to be able to ascertain its value on the open market. That's what the administrative rule requires. That's what our policy requires, and that's what this court's decision requires.
So it almost doesn't matter if under that definition, it doesn't matter if the contract says you can't transfer it. If you can evaluate the value on the open market, doesn't matter what the lease says, right?
If there was a restriction in a lease, it's still something that's available on the open market as a.
Right, you could still evaluate evaluate the value of the property,
Correct.
right?
Absolutely.
So why can't, despite the prohibition on transfer in the operating agreement, why can't these units, why is it impossible for these units to be evaluated?
Because there is no open market. The evaluation is simply based upon their determination or offer, right? We're trying to get $4.1 million that can easily be.
Well, just entertain me here. I mean, couldn't you get an appraisal on the property? Appraisal come back, it's worth $10 million.
She doesn't own the property.
No, right, I understand.
She doesn't own the property.
I understand. No, I understand that. Property's worth $10 million according to the appraiser. Then don't you just look at the number of units that have been sold?
I think that's the way they tried to set it up, but there's still no open market for what she purchased. I mean, they don't own property. Nobody purchased property buying into this. They didn't buy income-producing property. What they bought is 10,000 units or whatever it is.
What in the record establishes that the units could not be sold?
I'm sorry, I didn't hear the question.
What in the record establishes that the units could not be sold other than the operating agreement saying you can't sell them?
The testimony of the witnesses of Aaron Ray, and he's the primary representative. I was also wanting to reserve some time for Ms. Wakeman, and I don't know how much she needs.
Did she file the amicus brief?
Yes.
Yeah, normally amicus briefs they file the brief but don't make the argument.
Correct, but I know she did file a notice to appear in this case as far as making the arguments from that, but that's fine. We can proceed.
Yeah, go ahead.
Yes, sir. What was your question, Judge?
Well, I mean, I guess I was, wondering what the evidence was in the record that these units could not be sold on the open market other than the fact that the operating agreement says you can't transfer them.
Well, let me skip over. I'll get back to the...
I mean, and I can go look it up, right? So tell me whose
I'm
testimony.
going to give you the exact sites because
Okay.
I've written them all out, if I could just find them. Okay, Aaron Ray, at page 764 and 769, he basically states that there's no decrease in the value of ownership. That's what he's arguing. We intended the $100,000 to be equal to 10,000 units, so that's what we got. So that's fair market value, but that's not true. That's not what the law states. He also states it's unavailable, illiquid, unassignable, and there's no secondary market.
But that's out of the operating agreement, right? I mean, that's what the operating agreement says.
Correct.
So if the operating agreement didn't say that, could you sell these units to someone?
I guess that would have to be controlled by the terms of a different operating agreement or a different certificate that they were given that they actually signed and so on and so forth.
Well, no. Let's say there's no agreement on transfer, yay or nay. Is there someone? Let's say that the agreement says you can transform. You can go for it.
Mm-hmm.
Does the record establish that you can't find a buyer for these units under those circumstances?
No, it doesn't establish that. But at the same time, that's not what the record is. The record is you can't. It's impossible. That's the way Coastal Income Properties set it up. That's the way they designed it.
But because of the I feel like we're missing each other, but that's because of the operating agreement, right?
Correct.
Right. But if the operating agreement said something different, and the operating agreement said you can transfer, knock yourself out, transfer the unit, that's fine. If the operating agreement said that, could these units be sold to someone? Would someone buy them?
Of course, if it said that, I don't know if anybody would buy them or not. That depends on how sophisticated they are in understanding this. I mean, I read through the operating agreement. It was pretty tough for me. I've been a lawyer for 20 years. But, there's a lot of risk factors in there that the folks had to sign. You risk that you understand you can lose this $100,000. You don't need this $100,000, so on and so forth. I just find that was pretty, I don't know. I mean, I can't see somebody who is a layperson completely understanding that kind of document that they signed. And that's one of the other concerns I think the department has here is if you buy into what Coastal Income Properties wants you to do, you're going to really create, one, a situation where you're going to overturn your own case. Two, a situation where there's a real possibility for folks to be taken advantage of, which is something at the department, we try to guard against if we can. This
But that
situation.
really falls into the area of securities regulation as opposed to Medicare, Medicaid eligibility. So if the Department of Financial, whoever they are, has some concern about them selling illegal securities, that's really their bailiwick, isn't it?
Well, correct. I mean, a security is where, a group of people, pool their money together in hopes of making a profit. However, one of the most important things about when you're offering a security is you have to disclose the material information. What's really important here? And this whole transaction
But that's not really, I think Judge Orfinger's point is that's not really the issue before us,
correct.
right? I mean, the issue before us is whether or not she can get Medicaid.
Correct.
Right?
She entered into this, and the testimony.
It's not whether this was a good investment. We're not reviewing, the books
Correct.
to make sure that the property was worth a lot of money and
Correct.
things of that
You
nature.
can invest in whatever you want, but when you come to apply for Medicaid
Right.
institutional care program benefit, if you've taken something and done something with your money during that 60-month look-back period, you have to be able to show that you got fair market value for it. The way fair market value is determined is not at the time of the investment, it's what you can get for it. Once you make your application, what does the open market say? The code, the case law, and our policy, that's what it all says. They designed something specifically afoul of that. Thank you.
All right, thank you, counsel.
I will.
About this form, the department refers to it as the fake or whatever. I mean, what is
Your Honor,
that all
we-
about,
we-
and where does that come from?
It should have no place in this court's analysis.
I mean, it looks like it came
It
from
was-
the operators of the park to the department trying to essentially set up a formula to bypass all of these other.
No, Your Honor. It was put in the record by the department at the hearing. There was no attorney, there was no objection made, and there was also very little context given. What context there is in the record explained that that document was put in, was given to the department in the course of discussions, not even necessarily in this case, in other cases, where the representative was making an argument that based on the department's policies, that this is sort of an easy way to look at how this process should work. That's all it was. This notion that it's some kind of fraud or trick or whatnot is frankly, it's like the way this argument just ended, which is this sort of the department knows better kind of thing. These are things that are off the point of the issue. I heard two things that really caught my ear. First of all, counsel said that life expectancy doesn't matter because there has to be an open market. The department's position is there has to be an open market. If there's not an open market, then the value is zero. The law doesn't say that anywhere. Not in the federal statutes, not in the Florida regs. It doesn't exist, not even in their policy manual. But nowhere in the law does that principle exist, that there must be an open market. Counsel then later gave what I think is the correct way of putting this. Counsel said you have to ascertain its value on the open market. And this gets to something that came up in the court's discussion, that just because there's a prohibition on transferring doesn't mean that this security doesn't have a value. Its value isn't zero. Of course it can be sold, at least in...
It certainly has value to the heirs.
It has a value to anyone who has the right to it.
But it doesn't have, I'm not sure I'm convinced it has a value to her.
It certainly does, Your Honor. It absolutely
At least not a fair
does.
market value.
And the question is, ascertain the value on the open market. Not to her, to a person on the open market. If you were to try to sell this, if I hypothetically walked down the street and had in my hands a security that entitled whoever to $1 billion and said that it's going to mature in 5 years, and between now and maturity, you're going to get a 4% return paid out, annualized return paid out monthly. No one would think that was worth zero, but that's their position. They're relying on a principle that does not exist in the law, which is that there absolutely must be an open market, or we can't ascertain what the value would be on the open market. And I'll suggest that the court's comments earlier got to the notion that it's really a matter of valuing. And we had an evidentiary hearing, And at that evidentiary hearing, we're the only ones who came forward and even tried to express value. Their argument is a legal one, not an evidentiary one. If the court has any concerns well, first of all, going back to the notion that this final order is predicated on an error that's just flat incorrect, so that ALJ never got to where this discussion has been. And if the court has concerns about value, then I would suggest respectfully that what ought to happen is the case should go back. And we can present as much value evidence and whatnot as can be. Their position is a legal one. If the court follows the law, then this order should be reversed. Thank you.
Thank you. Thank you both. All right, we'll be in recess.